Imagine for a second that you are walking down this pristine sandy beach.
Okay, I'm picturing it.
Every single step you take leaves a really deep, distinct footprint. And usually, the tide comes in, washes it away, and the beach is totally clean again. But imagine if that footprint didn't wash away.
Right. It just stays there.
Yeah, imagine if instead every step you took was cast in plaster, labeled with your full name, time-stamped, geotagged, and then just stored in this massive infinite warehouse that you are not allowed to visit.
That is a terrifying image, honestly, but it's also a very accurate one.
It is, isn't it?
Go on.
Because that is essentially our life online today. I mean, every click, every hesitation on a web page, every transaction, every photo, it all creates this trail. And for a long time, that digital landscape felt like the Wild West.
Oh, absolutely.
Companies were just, scooping up that Sandar data and doing whatever they wanted with it, monetizing it, trading it, analyzing it.
And often losing it.
Right, and losing it. But the rules of engagement are changing rapidly, and that brings us to today's deep dive. I am incredibly excited because today isn't just a standard analysis. We are bringing you a special edition. Welcome to the WeCyberYou Unlocked podcast.
It is so great to be here. This is a massive topic.
It really is. Today, we are digging into a document that fundamentally changes how privacy works in one of the most dynamic business regions in the world. We are basing this entire conversation on the UAE Federal Personal Data Protection Law Handbook, which was provided to us by the team at WeCyberYou.
And just to be clear for everyone listening, that is WeCyberYou, 3 distinct words. They are a major resource for cybersecurity education. And the handbook they've put together is, well, it's essentially the Rosetta Stone for understanding this new legal framework.
So let's get into it. The mission today is to unpack Federal Decree Law name 45 of 2021. Now, I know.
Sounds dry.
It sounds like the driest string of words imaginable. It sounds like something you read to cure insomnia. But stick with us, because this is basically the new rule book for the digital age in the Emirates.
It really is. It's the United Arab Emirates' first comprehensive federal privacy and data protection framework. If you live there, do business there, or even just have customers there, this changes the game completely.
Okay, so let's unpack this a bit. We have this acronym, the PDPL. What are we actually talking about here? Is this just a copy-paste of other laws, or is it something unique?
So the PDPL stands for the Personal Data Protection Law. At its core, it is a modern law designed to regulate the entire life cycle of personal information.
The whole life cycle.
Right. We are talking about how it is collected, processed, stored, and even transferred. And what makes it fascinating, and the WeCyberYou handbook emphasizes this, is that it is designed with a global perspective. It actually came into effect on January 2nd, 2022.
Wow. Okay, so we are already living in the era of this law.
We are.
But I always wonder about the motivation behind these things. Why create this law now? Is it just about checking a box to look modern? Or is there real teeth behind it?
It is definitely not just checking a box. If we connect this to the bigger picture, it's about economic alignment. The UAE is a major global hub for business, finance, and tourism.
Right, it's massive.
Exactly. And to maintain that status in a digital economy, you need to speak the same privacy language as the rest of the world. The handbook points out that this law brings the UAE's regime in line with global standards, most notably the European GDPR.
Ah, the GDPR. That's the big benchmark everyone always talks about.
Correct. And the motivation is basically threefold: build trust, strengthen data security, and ensure transparent processing. In a global economy, data is currency. If international investors or tech giants don't trust that their currency is safe with you, they simply won't do business with you. It is infrastructure for trust.
That makes total sense from a macro level. But here is the big question that I think catches people off guard, and I really want to push on this a bit because it seems almost counterintuitive.
Go for it.
Say I have a small e-commerce shop based in, let's say, London, or maybe a sauce startup in Silicon Valley. I have never set foot in Dubai. I don't have an office there. But I sell to people in Dubai. Do I need to care about this? Or is this just for local companies physically sitting in a skyscraper in Abu Dhabi?
This is where it gets complex and where a lot of companies might get tripped up. The answer is a resounding yes, you do need to care. The scope of the PDPL is extraterritorial.
Extraterritorial. I mean, that sounds like legal overreach to some, doesn't it? How can they enforce a UAE law on a company sitting in California?
It's actually a common mechanism in modern privacy laws. The WeCyberYou guide breaks it down like this. The law applies to two main groups. First, obviously, organizations based in the UAE. That's the easy part.
Sure.
But secondly, and crucially, It applies to organizations outside the UAE if they're processing the personal data of individuals residing inside the country.
So geography doesn't save you. If you are targeting the market, you are subject to the rules of the market.
Absolutely. If you are targeting customers in Dubai or analyzing the behavior of users in Abu Dhabi to serve them ads, you are on the hook. Now, enforcement across borders is always tricky, involving international treaties and cooperation, but the liability is absolutely there.
Okay, that is a massive wake-up call for anyone doing international business. But before we panic, every business owner listening, are there exceptions? Because usually these laws have carve-outs.
There are. We should add a layer of nuance here. While it applies to both private and public sectors generally, there are specific exclusions mentioned in the WeCyberYou handbook. The law doesn't apply to government data handled by specific entities.
Okay, that makes sense.
But more importantly for the business crowd, it doesn't apply to entities in certain free zones that already have their own specific data protection laws.
Right, the UAE has these financial free zones, don't they?
They do. Specifically, the Dubai International Financial Center, the DIFC, and the Abu Dhabi Global Market, the ADGM. These are essentially their own legal ecosystems within the country. Yeah, they have had their own GDPR-style laws for years. So if you are registered inside the DIFC, you follow DIFC law, not this federal PDPL.
Yeah.
But for everyone else onshore UAE, the PDPL is the law of the land.
Okay, that distinction is vital, so we know who it applies to. Now let's talk about what it applies to, because when I hear personal data, I'm thinking basics. You have my name, my phone number, maybe my email address. Is that the extent of it?
It is so much more than that, and this is why reading the WeCyberYou handbook is so eye-opening. They expand the definition significantly to match how the internet actually works today. Yes, it includes the basics like names, photos, and ID numbers. But in our modern world, identity is fluid.
So what else is on the list that might surprise people?
Online identifiers, specifically IP addresses.
Wait, IP addresses are considered personal data? I think most people view an IP address just as a technical routing number, not a person.
They are personal data because they can identify a specific device and, by extension, a specific person's location and identity. If you combine an IP address with a login timestamp, you know exactly who was where. But it goes even deeper. The law covers biometric data, your fingerprints, Face ID, and this is the one that really matters for the future, behavioral data.
Behavioral data. That sounds a little dystopian. What does that actually mean in practice?
Think about how you navigate a website. What do you click on? How long do you hover over an image? What time of day are you online? Will you scroll fast or slow? It's not just who you are, it's how you act.
It was like your digital body.
Digital body language, exactly. Yeah. In the age of AI and algorithms, this behavioral data is used to predict what you'll buy, how you'll vote, or what you'll watch next. The PDPL recognizes that this digital body language is unique to you and deserves protection.
That is a significant shift. It moves the goalposts from protecting a static file in a cabinet to protecting the dynamic persona of a human being online. So if I'm an organization, let's say I'm that startup we mentioned earlier, and I have all this data. I have the IP addresses, I have the shopping habits. I can't just hoard it anymore, right? I can't just keep it just in case I want to sell it later.
No, the days of data hoarding are over. The WeCyberYou handbook outlines a fundamental shift in responsibility. You need a valid legal basis to process that data. You cannot just collect data because you might need it someday.
Legal basis sounds like lawyer speak. What does that mean for a marketing manager or CTO?
It means you need a justification. The most common one is consent. The user actually said yes. But the law is strict on this. Consent can't be a generic checkbox hidden in a 10-page document nobody reads. It has to be clear and specific. Another basis is contractual necessity, meaning I need your address to ship you the shoes you just bought.
But I assume contractual necessity has limits. I can't say I need your health records to sell you a pair of shoes.
Correct. You can't just take the address for shipping and then sell it to a third-party marketing firm. That violates the purpose limitation.
That brings us to the obligations. The handbook lists a few key pillars for organizations. What are the big ones we need to watch out for?
There are 4 or 5 that really stand out. First is transparency. You have to tell people what you are doing. No more black box data processing. Second is minimization.
Minimization.
It means only collect what is strictly necessary for the specific purpose. If you are building a flashlight app, strictly speaking, you do not need access to the user's contact list, their location history, and their microphone.
Oh, I am so tired of calculator apps asking for my contacts. It feels completely predatory.
Under the PDPL, that is likely illegal. It's a violation of the minimization principle. Then you have accuracy data must be kept up to date. You can't make decisions about people based on 5-year-old data that might be wrong. And finally, and this is huge, security. Organizations must implement technical and organizational safeguards against breaches.
So cybersecurity isn't just a nice-to-have feature anymore, it's a legal requirement.
That is the reality. If you are sloppy with security, if you leave a server unprotected or don't encrypt sensitive files, you aren't just risking a hack, you are breaking the law.
This feels like it really turns the tables. Usually as a user, you feel powerless. You just click accept all because you want to read the article and you hope for the best. But this law seems to give some real power back to the little guy.
It absolutely does. The section on data subject rights is crucial. It transforms the user from a passive source of data into an active participant.
What kind of rights are we talking about here? Can I just demand to see what you have on me?
Yes, that is the right to access. You can ask an organization, what do you know about me? And they are legally required to provide that information in a readable format.
That is powerful. It forces companies to actually know what they have, which, let's be honest, many don't.
It gets better. You have the right to correct or delete. This is often called the right to be forgotten. If the data is wrong, or if you just don't want them to have it anymore, and there is no legal reason for them to keep it, you can demand they wipe it.
I want to pause on that, no legal reason. Because I feel like there is a tension here. Can I call my bank and say, hey, I want you to exercise my right to be forgotten and delete my loan history?
That is the million-dollar question, and the answer is no. The WeCyberYou material is clear that these rights aren't absolute. If the bank has a legal obligation to keep records for financial auditing or anti-money laundering laws, that overrides your right to deletion. But if you signed up for a newsletter 5 years ago and you want out, yes, they have to delete you.
Got it. So it's a balance between my privacy and the law's broader requirements.
Exactly. Then there is the right to restrict or object to processing. So you might say, okay, you can keep my data for the warranty on my car, but I object to you using that data to market new tires to me.
And finally, I saw data portability on the list. That sounds like moving a phone number to a new carrier.
It's a similar concept, but applied to all your data. It means you should be able to take your personal data from one service and move it to another in a structured, machine-readable format. It prevents vendor lock-in, where you stay with a service just because they have all your history and you don't want to lose it.
That is actually really pro-competition, if you think about it. It forces companies to be good enough to keep you, not just hold your data hostage.
That is a great way to put it. It empowers the consumer to switch providers without losing their digital identity.
Okay, let's zoom out a bit. We talked about the global nature of this earlier. The internet doesn't really have borders, but laws do. What happens if a UAE company wants to send my data to a server in, I don't know, a country with really weak privacy laws? Is that allowed?
That is the issue of cross-border transfers. And the short answer is yes, but with major caveats. Data can leave the UAE, but only if the recipient jurisdiction provides adequate protection.
So no data dumping.
Correct. You can't just ship the data to a data haven where there are no rules. If the other country doesn't have strong laws, if they don't have an adequacy decision from the UAE, the organization has to put appropriate safeguards in place themselves. This usually means specific contract clauses that force the receiver to protect the data as if they were in the UAE.
That is reassuring. But laws are only as good as their enforcement. Who is the sheriff in this town? Who is making sure companies actually do all this?
That would be the UAE Data Office. They are the regulator established to enforce compliance. They are the ones who will handle complaints and conduct audits.
And do they have teeth? Or is this just a sternly worded letter situation?
Oh, they definitely have teeth. The WeCyberYou handbook mentions administrative fines and legal consequences for noncompliance. It is not just a suggestion. And frankly, in the business world, the reputational damage of a public enforcement action can be way worse than the fine itself.
We are seeing that globally. Privacy is becoming a brand asset. If you are the company that leaks data or gets fined for mishandling it, you lose customer trust instantly.
And that connects to the technological context the handbook highlights. We aren't just talking about spreadsheets anymore. This law is crucial for the era of cloud computing, AI, and social media.
Right, because the scale is just so different now.
Think about it. When you have automated processing and AI making decisions based on data, the risks are exponentially higher. If an AI denies your loan application based on biased data or data you didn't consent to giving, that's a massive problem. This law forces cybersecurity and privacy to be a priority, not an afterthought. It forces companies to build privacy into their architecture from day one, what we call privacy by design.
It's like building a house. You don't put the locks on after you've built the whole thing. You design the house to be secure from the blueprints up.
Spot on. And for international organizations, this alignment is key. It makes the UAE compatible partner for Europe and other regions with strict laws. It smooths the flow of digital trade because everyone is playing by the same rulebook.
So, to summarize what we've learned from the WeCyberYou handbook today, the PDPL isn't just red tape. It's a modernization effort. It applies to almost everyone processing UAE data, regardless of where they are physically located. It redefines personal data to include things like behavior and IP addresses, and it gives us, the users, actual enforceable rights to control our digital lives.
That is a fantastic summary. It is about accountability. It is about saying that in a digitally connected world, your personal information belongs to you, not the highest bidder.
I appreciate that perspective. It really does feel like we are growing up a bit as a digital society. We are moving out of the Wild West and into a civilization with actual rules and rights.
But here is a thought I want to leave you with, and it is something the source material hints at with the mention of behavioral data and AI. The law is written, and it is solid. But the technology it regulates changes every single day. As artificial intelligence becomes more predictive, using that behavioral data we talked about to anticipate our needs before we even know them ourselves. How will the interpretation of these privacy rights evolve? Can you effectively object to processing when the processing happens in a split second by an algorithm that has already predicted your next move before you've even had a chance to click a button?
Wow. That is a heavy thought. The law is set, but the target is moving. If the algorithm knows what I want before I do, did I ever really have a choice to consent?
It raises an important question about the future of human agency in an automated world. The law protects your data, but protecting your autonomy might be the next frontier.
Well, that is definitely something for you to mull over next time you see a targeted ad and wonder, how did they know? Listen, this deep dive has been an absolute eye-opener. I want to remind everyone that today's show was powered by the incredible information from WeCyberYou. If you want to get smart about this stuff, and clearly you have to go to the source.
Absolutely. Make sure to follow this channel and visit WeCyberYou.com for more educational cybersecurity content like this. They make these complex topics accessible, which is a huge service to the community.
WeCyberYou.com. Go check it out. Thank you so much for joining us on this special edition of the WeCyberYou Unlocked podcast. We will catch you on the next deep dive. Stay safe out there.
Goodbye, everyone.